Okay, Mary, we are recording. We're waiting for one more person to join. Just a reminder that with the new state law changes, we are not holding a public hearing. Mary, can you hear me?
Hi.
Hi. Okay, good.
Okay.
Yeah, we're just waiting for Sarah. It looks like she's about to pop on. I'm gonna move Tierney over. Okay. All right.
Can you see? Am I there?
You are. I can see your
I
screen.
sort of lost my visual and I'm just trying to find it. There I am. Okay.
Okay.
Sorry about that.
No, that's okay. I think we're
The
good to go.
hotel seems to have a little bit of an unstable internet connection.
Oh, no. Okay. We'll keep that in mind.
Okay.
It looks like we've got everybody we need. You're good to go.
Okay. So I am calling to order the Salt Lake City appeals hearing on PLN APP 2025-00408. The appeal of a denial of a certificate of appropriateness by Tierney Snyder Guard regarding a property at 722 South, 700 East. My name is Mary Woodhead. I'm the hearing officer today. And will everyone present please make a notice of appearance?
Paul Nielsen with the Salt Lake City Attorney's Office.
Sarah
Marley.
Deveronic. Sarah Deveronic with Salt Lake City Planning.
And Meyer Lima, Salt Lake City Planning.
Aubrey Clark, Salt Lake City Planning.
Okay, sounds good. How I'd like to proceed is I'd like to hear from Salt Lake City Planning first to lay the groundwork for the issues relating to this appeal, and then I'll hear from the appellant, Ms. Snyder Guard. Then from Salt Lake City, Paul Nielsen, and then I will allow Ms. Snyder Guard the last word since she's the appellant. I have read all of the materials, so I don't necessarily need to have all of the details repeated, but you're welcome to say whatever it is you need to say. So I will turn it over to either Sarah or Mayara, whoever is presenting for the city.
Thank you. I'll be presenting for the city at first. So I'll try to be brief. So there are 3 items that are part of this appeal. The first is painted brick. The second is replacement of the stone or concrete cap. And then the third are the replacement windows. In the administrative decision, staff found that the request did not meet 7 of the 11 standards for alteration of a contributing structure. And these are in 21A 34020G. And then also it did not meet 11 of the applicable residential design guidelines. And in this particular case, the work is already complete on the property. Staff initially reviewed and approved with a certificate of appropriateness or COA, the replacement of several windows in 2019. This was the result of an enforcement case, and the appellant did not obtain a building permit for the replacement of the windows. And so a notice of non-compliance was subsequently recorded on the property. And then late last year, the appellant reapplied to obtain a new COA since the first expired after a year for these windows, and staff became aware of painted brick, which had not been painted in 2019, as well as replacement of the stone or concrete caps and additional windows that were replaced beyond or in a different manner to what was approved in 2019. And since then, staff and the appellant have discussed options to reach an agreement, but were ultimately not able to, and staff issued an administrative denial on April 21st. And in this, staff found that the painted brick does not meet 6 of the applicable standards in 21A 34020G. These are standards 2, 3, 5, 7, 8, and 9. It also does not meet 3 guidelines in Chapter 2, building materials, of the residential design guidelines, which are a supplementary document that provides guidance on implementing the standards. And while there is discussion on potential previous modifications to the brick prior to the painting of the brick lavender between 2019 and 2021, which was completed without a COA, the brick was not painted as it is today. As far as the replacement stone or concrete cap, this does not meet this does not meet 6 of the standards in 21A 34020. Specifically, these are standards 2, 3, 5, 8, 6. 2, 3, 5, 6, 8, and 9, and it does not meet 4 of the guidelines in Chapter 2 of the Residential Design Guidelines. It doesn't have the same character, the scale, the size, proportions, or finish as the concrete cap that was there previously. As far as the windows, planning staff approved some of the replacement windows with a separate minor alterations application, and the remaining replacement windows are visible from the right-of-way, and per the standards and guidelines, these are reviewed differently. And so the replacement windows do not meet standards 2, 3, 5, 6, and 9. And then 4 of the guidelines in Chapter 3 windows in the residential design guidelines. 3 of the openings previously had 3 windows that were replaced with a single slider, and these replacement windows do not match the original design or profile. And then additionally, the front window was replaced, which was not approved with the 2019 COA. And so staff issued the denial based on the painted brick and the replacement materials not meeting the standards and guidelines.
Can I ask you about 2 things? One
Sure.
is there was a reference in the staff report to the fact that some deeds, when people purchase homes that are in historic districts, have notations so that people have some notification of that, and some don't. Can you tell me more about that history?
Sure. So generally, when a historic district is established, the city records with the county recorder a notice on the property, basically letting future property owners or purchasers know your property is now in a historic district. And we did look on the recorder's website to see if that was recorded for this property, and it wasn't. I think for Central City Historic District, this was recorded in 1995, but it didn't show up for this one. However, when you apply for a building permit, or the city has also sent out postcards the past few years letting property owners know they're in a historic district. So there are other methods for becoming aware of your property being in a historic district.
Okay. So anytime you replace windows, you have to apply for a building permit, and when you did that, you would get the notice.
Right. When you apply for the building permit, there's essentially a flag that comes up on your property that says this property is in a historic district.
Okay. And what happens, and I understand this is one of the things Ms. Snydergaard alleged in her appeal, is when someone just doesn't have the finances, that, the house is existing, it's functioning the way it functions, and complying is fairly expensive. Is there any process that makes any recognition of that?
Basically, what we do is we follow the standards and the guidelines. And so those are what we use to kind of provide guidance for making decisions.
Okay, thank you. Okay, I am going to turn the time over to Ms. Snydergaard. So, tell me about your appeal.
Okay, now I'm unmuted. Hello, I'm Tierney Syndergaard is how you pronounce
I'm
it.
sorry about mispronouncing your name. I apologize.
That's all right. Both of them are doozies. I'm used to it. I was told I had brief 10 minutes, so to make sure I went under that time, I just wrote everything out. So if you hear me out, I just have this written up. Thank you for your time and attention for hearing me today. I am here to appeal the administrative denial regarding my property at 722 South, 700 East in Salt Lake City. My home is a patchwork of architectural styles, additions, and remodeling done over many decades, long before I ever owned it. No one can say for certain what it looked like in 1915 or even 1975 because no photographs even exist until a black and white of 1991. The historic record is sparse, and what little documentation exists consists of property tax cards, reappraisal cards, and some building permits, none of which actually capture the original structure. However, 3 legal documents do exist stating a building date of 1915 have been presented in the report. In fact, the oldest property tax card, which is also a building permit, as you can interpret, found on pages 94, 95, 101, and 101, 100 and 101 of the Historic District staff report, documents significant alterations, including a front porch addition and a glass rear addition. This is verified by a reappraisal document also found in the report on pages 103, 109, dated 1936, and on page 106, the card states record of assessment of improvements, signifying changes significant have been made, and reappraisal card also dated 1936. Typed is the name Bertie Price Lloyd. These changes are also verifiable by the house's interior ceiling height. The original 4 rooms of the house have 10-foot ceilings, typical of the 1915 construction, whereas the front and rear house, however, only have 8-foot ceilings, clear evidence of later work. In the guidelines booklet, it states under the concept of integrity, in addition to being historically significant, a property also must have integrity. To have integrity, a sufficient percentage of the structure or site must date from the period of significance. The majority of the site's features or the building's structural system and materials should date from that period of significance. Its character-defining features also should remain intact. Confusing the character by mixing elements of different styles would not respect the historic design character of the building. The original house dates from 1915, had a Victorian influence. As can be seen, on the north and south middle exterior walls, they have scalloped rock designs. But the later addition on the front and the rear, you can see a bungalow style, and the evolution doesn't stop there. Physical evidence and the photographs I've submitted in the report show that 2 of the 4 original chimneys were demolished when a new roof was installed. They've been knocked down. The rear glass porch that it talks about in 1936 was totally enclosed on the rear and is now 2 full bedrooms. Closets were installed over existing windows on the north wall. Aluminum siding was added to both the front and the back of the house. Window seals on the entire back of the house were wrapped in aluminum. The aluminum window seals were later painted as well. The front porch was fully bricked to create a more interior space. A metal south porch was added on the south side. Windows were replaced with metal framed ones in the front, and as probably at the same time the front brick was added. Paint was added to cover and mask the mismatched brick style colors and construction materials before me, and over the years a few windows were repaired and or replaced as needed. Some of these changes are verifiable with building permits. Others, like most of the changes on the house, have never been recorded and no permits have been found. To provide expert support, I've invited Casey Sullivan. He is here from Abstract Masonry in Salt Lake City. He personally inspected my home in February and submitted a letter included in my appeal documenting the physical evidence that the brick was painted prior to my ownership, along with his professional assessment of the front facade's approximate construction date. He will speak when I am through. I also submitted text messages that the chimney that Casey Sullivan looked at was original and not painted because the paint.
I have read the staff. I've read the report, so I've looked at all of those materials.
Okay, great. Additionally, I've invited Amy Gibbons to speak, a seasoned real estate agent in Salt Lake City. She actually represented me when I purchased the home in 2008 and can speak firsthand to the condition and appearance at the time and has evidence to say so. The design guidelines specifically acknowledge that 5 of the 14 historic district neighborhoods, including Central City, have their own unique goals and guidelines, warranting a separate set for each neighborhood. These guidelines for Central City state the most significant feature of this district is its overall scale and simple character of buildings as a group and as part of the streetscape. Because of the overall street character, it is the greatest concern. More flexibility in other areas, particularly renovation details, should be allowed. This goal for preservation should also be considered in the context of the related neighborhood goals to attract investment and promote affordability. My house looks like my neighbors' homes. The brick is painted, the windows are updated, the character and scale of the street are intact. My neighbors' homes have been allowed to stay in their updated, renovated looks. This helps to promote attractive investment and affordability for our street, especially with such a commercial area. It is unfair and frankly arbitrary for the historic district to enforce some vague general rules while disregarding the more flexible guidelines written specifically for my neighborhood and district. This has created an environment where the private citizen is left at the mercy to interpretation on how strict or lenient the individual planner decides to be on a case-by-case situation. In December, when I was preparing to sell my house, my tenants moved out, the house was listed by the realtor, and when the historic district denied my application, I worked for months trying to find affordable compromises. I submitted proposals, photos, cost estimates, but none of the things that I suggested were accepted. They would not budge. In the meantime, I have drained over $13,000 from my savings to cover the mortgage and utilities because I never found renters. I've also lost more than $15,000 in rental income. The cost of the required changes that I put and submitted bids would exceed $60,000, equivalent to my husband's full annual income. These alterations would also not enhance the home's value. In fact, they would significantly diminish it. This house means everything to me. I bought it with my mother's help. I went on my first date with my husband in this house. I got married in this house. I love downtown so much. I had my wedding reception at Liberty Park. 3 years went by, and my mother died, the one that helped me buy it. Her name was left on the mortgage for years because I didn't want to stop seeing it on the report every month when I got the mortgage payment. This house helped me buy a plot in Salt Lake City Cemetery at the discounted rate for residents where she's buried. You can drive up N Street. Kathleen Johansson, she shares a bench with my father. If you ever go up there, it's beautiful, and there's surprises on the bottom of it worth looking at. All of these memories are personally tied to this house. I love it more than anyone else here or alive in Salt Lake. No one has cared for this house more than I have. I never made more than $5,000 a year, never needing to make even a tax statement in Utah because every dime I had, I put back into fixing this house up. And yet, I am now being told what the house was, what it looked like, and what should be done with it by people who have never set foot inside the home to verify these things. Unfortunately now, this house has no famous residents, no famous past, not even an old picture to verify what it even looked like. But now because of me, there are more pictures and documentation of it than ever before, and for all of the wrong reasons. Now I want to briefly respond to the 3 specific claims the Historic District staff report made. In Claim 5, they actually quoted in their report that the brick and mortar of the front 1/3 of the building is indicative of the time period that Casey Sullivan stated, and that the front of the house had potentially the brick replaced. This supports that Casey Sullivan's evaluation is correct, and with no photos or permits to confirm otherwise, we must rely on the visible physical evidence we see, since few permits are even available to verify the changes on the home. In Claim 7, I wanted to verify. I tried for months to work on alternatives that were more affordable. I made suggestions that would not be as expensive, but still allow for the aesthetic older look to remain, and they were denied. No compromise was either offered by the staff that would preserve the value of my home and address preservation goals to meet in the middle. In Claim 12, the original denial issued on December 5th of 2024, it addressed only 2 windows. However, 3 months later, when I said I would be addressing an appeal, that they added 2 more windows, one of which was already approved for replacement in 2019. 2 of the windows addressed, I explained, were vandalized and broken into. And per the guidelines, it says if your broken window is more than 50% demolished, you may replace it. I submitted the police report to show for that vandalism. The 2 north wall windows are also in bedrooms. The original 3 opening windows cannot meet Salt Lake City egress code for bedrooms. You need 5.7 square feet of an opening, and a 3-panel design provides for only 3.39. With the math to be safe and legal for bedrooms, which I have to be, 2 panels are required to maintain the same window opening as it stands, unless we want to enlarge the whole window opening. At the time of my purchase, the back half of the house had already had every window covered in aluminum siding. This can be seen in pictures 43, 46, and 50 of the denial report. The aluminum wrapping had also been painted. No windows were also even visible from the front of the house because everything was covered in metal storm windows. In closing, I'm asking to be allowed to leave the house in the current condition based on the facts that 1, the brick was already painted before my ownership. Two, the home has already been remodeled and altered repeatedly across decades into a non-original, multi-styled structure. The physical and architectural evidence clearly shows mismatched additions and designs, and that restoring the bedroom windows to the original size would violate current egress codes. Replacing the other windows to match what no longer exists on the home does not serve preservation, especially when they were already altered under aluminum siding and metal storm windows. The capstone on the front porch was most likely built in the 50s and 60s, as we can see in the brick evidence, and so it is generic in style and not unique to any specific time period significant. Enforcing these expensive changes without any photographic proof of the original home or its looks puts a very large, unreasonable financial burden on me and my family, and it massively lowers the value of this home. This house doesn't reflect a single time period or a single specific style anymore. Its integrity has been diminished. It reflects the passage of time and the many people who lived in it, like the working class it is. I'm simply asking to be treated reasonably and fairly and in line with the flexibility that's already been promised by the Central City neighborhood guidelines. Please allow me to continue to preserve this home in a reasonable, affordable, and respectful way. Thank you.
Thank you. You mentioned that you had brought other people.
Yes.
Did they have testimony that's not in the staff report?
Yes, they have different things to add. Amy has some more evidence that she located, and so does Casey.
Excuse me?
Yes, they do.
So, okay, this is not a public hearing, and usually we don't allow extra testimony, but since you brought them, and I'll give them each 5 minutes.
Oh, okay. I told them too. So,
Okay, 2 is fine then. If they can give me 2 minutes, that would be great.
yeah,
Thanks.
Ms. Woodhead, I don't object to that because it's not a public hearing, but these are not people who are testifying as members of the public. They are her experts, and the city's totally cool with that.
I'm gonna let them come in as experts for 2 minutes.
Do you want me to start then?
Identify yourself, please, and tell me what.
Yes, my name is Casey Sullivan. I am owner and partner with Abstract Masonry Restoration. We're just masonry restoration contractors here in Salt Lake City.
Yes, and I have read your report, so
Okay.
I'm only interested if you have something to add that's not in the report.
Just wanted to reiterate my professional opinion that the yellow brick on the house below the eaves has been painted previous to the blue paint. Yeah.
Okay, thank you. I don't think I need anything else.
Okay.
Tierney, you said you had someone else?
yes, Amy Gibbons.
Okay, am I okay to start?
Okay, Amy, why don't you identify yourself for the record?
I'm Amy Gibbons, resident of Salt Lake County and realtor of 19 years in Utah.
Okay, and you were involved with this particular property?
Yes, so I personally represented Tierney when she purchased this property in the spring of 2008. Looking at a chain of title, which I pulled from the title company, the Lloyd family owned the home from 43 to 74. The Theobalds, they sold to the Theobalds from 74 to 76, and then the Esplin Carters owned it from 76 until Tierney bought it. All of the previous owners are deceased. We've done substantial research to see if we can get pictures from the family members over the course of the years, but unfortunately they're all deceased. As already stated, the 1995 adoption into the Central Historic District was not recorded on this property. I was able to verify that with title as well. And then what I wanted to bring up is that I have an original home inspection that was done in 2008 on the property. The report shows that the home had a combination of both aluminum and wood windows that, this is a quote, are damaged or inoperable at the time of the inspection. It's page 11 of the inspection report, which you don't have. And on the cover, you can see that the exterior of the home matches the other photos in the staff report.
And can you submit that entire report for the record?
How do I
email
submit
to Salt Lake City so that it's part of the record, so that
How?
everyone has a copy of it.
What's the email address?
You can submit that to planningadmin@slc.gov.
Okay, thanks you guys. Okay, the other thing that I wanted to bring up, this property is located next to a Domino's Pizza. There are 2 motorhomes next door, which are illegally housing employees of the restaurant.
Okay, that's not relevant to this hearing.
Oh, well, I'm trying to just give you a little bit of background because this has made this home a target for vandalism and illegal activity, which is our suspicion behind the windows that Tierney had to replace at a later date, which because they had been vandalized. That's why I wanted to bring that up. Tierney's done a substantial amount of work on this home since it's been purchased. It's become a stable centerpiece to the area next to commercial use, and she's been proactive in keeping the area safe by notifying police and city workers when illegal activities are happening in her community. She's friends with her neighbors who live in their homes part-time. Those are the homes adjacent. They support one another in keeping.
Stop you right now. This isn't a public hearing.
Oh,
So, I allowed you to testify with the idea that you had some expert testimony to offer, and you have offered some helpful information and some documents, but general information about the character of either the appellant or the neighborhood is not isn't admissible at this point.
okay. I was misinformed when I talked to a person who was on the board and they told me what was allowed. So thank you.
Okay, thank you. Okay, I'm going to now turn it over to Paul Nielsen for Salt Lake City.
Thank you, Ms. Woodhead. It's good to see you. I'm going to apologize for not staring into the camera. I've got 3 screens, and the way that my computer connection sets up, you're looking at the side of my head, and I'm sorry for that. I appreciate that you have read the materials submitted. I'm not going to try to be a planner, but I think that there are principles in the code that maybe Sarah can confirm, or maybe Mayara. And I'm going to qualify this with, I haven't been a land use attorney for 1.5 years or so. So I'm pinch hitting, but I still think I think I can still do it. I think that some of the ideas that were brought up about changes to the structure over time will probably be addressed as things that can establish their own historical significance given a period of time that passes. Again, I'm going to lean on our planning experts to address that. But I did want to just sort of reiterate the cases that were cited for purposes of taking. Nolan and Dolan are cases that deal with actual exactions, physical taking of property. The Money versus San Marcos case doesn't really apply here because we weren't talking about historic land use regulations. The Hanna versus City of Chicago was about vagueness, and the items that the appellant pointed to as being vague were purpose statements from the guidelines, and we acknowledge that purpose statements. I mean, it's not news to you, Ms. Woodhead. The purpose statements don't have any sort of binding effect. They're usually just background, and they try to paint a picture of what the regulations do. And in this case, we're talking about the regulations in section 21A 34020. And those have been addressed by staff in the staff report. And the items that the appellant claims are vague were not part of that assessment. Pointed out that I tried to find the Eli versus City of Pasadena case. I've learned a lot about artificial intelligence lately and how there are these things called hallucinations where artificial intelligence creates things that aren't real. I think that's what that is. Uh, Either way, there's really no discussion of that case. And since it's not reported, I don't know what to do with it. Finally, I would just point that the Fifth Circuit Court of Appeals, which federal cases can be not necessarily binding, but that they can be instructive from other districts, where the 10th Circuit that we're in hasn't necessarily dealt with this specific issue. But that is a case from 1984 where they were dealing with an historic district in Dallas, Texas, where somebody had painted brick on a house in a historic district. And the court in that case deferred to the findings of the local land use authority and upheld those determinations that the painting of the brick was in violation of the historic regulations. And because you indicated, and I know and trust that you read through the materials, I'm not going to go into any of this further. If there are any specific legal arguments you want me to address, I'm happy to do that. There was language about unconstitutional conditions, and again, those are really exactions cases.
I'm familiar with that case law, so that's fine.
Yeah, cool. That's all I got.
Okay. Does anyone else from the city planning staff have any response to the arguments Ms. Syndergaard made?
I do want to respond to a few different things. So one thing that I want to respond to is that we do recognize that there have been some alterations to the property over time, but there is a separate process to evaluate whether a property remains contributing or if it's non-contributing, and this isn't that process. As far as some of the proposed windows in the bedrooms and building code issues, I did discuss this with the plans examiners and building services. And generally, when a property owner replaces a window, if you're not making it less conforming, you could replace kind of an existing window with the same window. And so I'm willing to work with her on making those windows meet egress as much as possible. But that is something that I did look into.
Yeah, I did have a question about that.
Yeah.
There are egress building code requirements and they conflict with the historic district requirements. I presume that safety and egress, there needs to be a way for those things to work together.
Right. So generally what it is if you have a building that has an existing window that doesn't meet egress, you can replace that window with another window that also does not meet egress requirements. You just can't make it any less compliant with egress requirements. And again, I'm not a plans examiner, but I did talk with them about this.
And if a homeowner wants to make the house safer by having a bigger window, what does the historic district rule say about that?
So what we've done with other properties when they either need to meet egress or want to meet egress is we've usually worked with them to kind of set up some sort of a bar or some sort of like exterior feature on the window that kind of notes that there was that divider that was there or something along those lines. That's what we've done in the past.
Okay.
And just one other thing, I think a number of the changes that we were discussing, they likely occurred more than 50 years ago. And so like Paul brought up in the beginning, things that are over 50 years of age can also be considered historic as well. And so we want to look at those aspects of it as well.
Okay, thank you. Okay, I'm going to bring it back to Ms. Syndergaard. And please give me any response you have to what you've heard from the other parties.
Yes. So to change the windows to what Sarah's discussing, if they can't fit the original look, changing the windows is actually contrary to what she's saying of saying, well, we can bend the rules for us to fit egress, but still have this design. These windows are very small, so 3 window panes doesn't fit in. I suggested in some of the submissions, the front window and the side windows are the exact reveal, the exact even window 3 size for what it is, and they were covered with storm or with vinyl, so you couldn't see them. So I suggested framing them out in wood, where they would then have that old look, and they flat out denied it. But that is way more affordable than replacing windows that are already in, that have the same look and fit in the same windows, but are at a fraction of the cost. But I was denied early on any of the other suggestions as well. Same with the stone capstone in front. The original design was a very poor flat design. That's what led to the crumbling so quickly of it, is that the cement was so thick. So the brick mason that I had said, this isn't possible to do again because it is against the design, and you need something tapered for the wall to, for the water to come off and not slide down into the brick again. So that's why he suggested doing that, which is a much better design to keep the water from off of the porch like it should be. I also wanted to suggest and say that I feel that once I set up the appeal, that this wasn't about historic preservation. I felt that this was more punitive, and that I was being punished as a homeowner for trying to make my neighborhood and house nicer. And instead of trying to compromise on a financial thing that would benefit both parties, nothing was ever met in the middle. It was only denied. I also was a little bit surprised that when I put in for the appeal, I was still forced to communicate and do everything with the historic district, the people that I felt were not helpful in me and that were a little bit against me, not a little, but a lot. I was then forced to submit all my appeals and do everything with them. And then they were the ones involved in writing the staff report. I was surprised that Salt Lake City would not have an unrelated third party do the staff report and have it brought together in an unrelated manner. And so that was a little bit surprising that I felt like there was some conflict of interest of how this has been set up, and unknowing of how it would work.
The staff report represents Salt Lake City's position, so it's appropriate for Salt Lake City to do that. And I'm contracted and I don't work for Salt Lake City, so I'm the outside person who reviews everything.
Okay. So the other thing that I was saying is when they said there's nothing in the guidelines that talks about adverse effects to the financial obligations, it does many times over say if you feel like this is adverse, why would you appeal? Because this will cause financial ruin. That's the same equivalent as my husband, that the changes, you would think if there was way to compromise that both parties could fit, that we would have found it, but everything I suggested was denied. And I feel like this arbitrary house that has no history is now more valuable to Salt Lake than a human's financial well-being for the next 5 years of my life. I do not have this money. It will come out of my 401k of my husband. So it now will affect the next decade of our lives to make a house that looks like the neighbors, that is exactly in conformity with all neighbors that made the same changes, and they're not being asked to change them. So there is some unfair treatment, because the statement said by them in the staff report, we treat all people the same. If there is a complaint from neighbors, then we get involved. I had no complaint from neighbors. This was only brought up because the certificate of appropriateness was out of a year. It expires. I asked for a new one. They wouldn't just reissue it. She said, well, I have to come inspect the house again to do that. There was no complaint. So when these things started, I am on great terms with my neighbors. Their houses look exactly like mine. They're both out of town a lot because they're pilots. But for me then to have to change when their houses look the same as mine seems very arbitrary and very punitive in nature, that, well, we're going to let so-and-so and everyone else get away with it. But the person that's been here the longest, that has owned the house the longest, we're going to be making sure that you take the biggest financial brunt possible. When I followed the rules, the house was absolutely painted. The windows had been changed and altered before. In the report that Amy will submit, it says there were aluminum windows and wood windows. There was a combination of both on the house before I even owned it. So a lot of these things were changes before I even had it. And that's what I wanted to say, is that this is the state of a house, is that they're saying that this home in its current condition and its look is valuable more than me. I have a buyer. It is under contract right now to sell. They are not interested in buying the house if I have to unpaint it. They said, we are not interested if these changes are made because that makes us not want to be involved in a home that's in a historic district. We are massively deterred. They have explicitly put that in the contract. So whatever happens in this appeal, I will potentially lose the sale of my house, and then I don't know what other financial ruins lie ahead. So then it is a takings clause because my life is then completely changed.
I just want to, it's not really relevant to the appeal, but did you say that they said they wouldn't buy the house if it's in a historic district?
No, if I have to unpaint it because of historic regulations, they are not interested. And Central City actually has the lowest property values of all 14 historic districts. Of any of them, the lowest property values of the whole downtown Salt Lake historic neighborhoods. This one is already the lowest.
Okay. Anything else? Okay, I'm going to take this under advisement. I appreciate all the time and effort everybody has put into this. I appreciate you bringing some people with some additional information. Ms. Syndergaard, it will probably be toward the end of next week. I'm out of town right now, and I will issue a written decision. And thank you again, everyone.
I appreciate it.
Thank
Any
you, Ms.
other
Head, and
questions?
thanks to the appellant for the time that she's put into preparing for this hearing.
Okay,
Good
thank
job.
you, everyone.
Thanks, Mary.
Bye.
Thank you.